My name is Ayoub Ahmed, and I am the community organizer at CARE Washington. Today, I wanted to bring an important case to the community's attention. On Monday, January 8, CARE attorney Gadir Abbas will argue FBI versus Fikr at the U.S. Supreme Court, a case arising out of Jonas Fikr's unlawful placement on the FBI's secret no-fly list. Fikre is a Muslim who the FBI attempted to pressure into becoming an informant, tortured, and imprisoned in the UAE at the behest of U.S. officials, and he was stranded in Sweden because of his status on the no-fly list. CARE and co-counsel sued in 2012, and after 4 years of litigation, the FBI removed Fikr from the no-fly list without explanation. The FBI now seeks a decision from the Supreme Court that would, in effect, permanently insulate the secret fly list from judiciary scrutiny. Jonas Fikr is a naturalized U.S. citizen from Eritrean descent. At some point in 2009, he moved to Sudan and began a business venture that involved selling products in East Africa. During a 2010 visit to the U.S. Embassy in Sudan, Fikr was approached by two FBI agents. The agents interrogated him concerning his association with a mosque in Portland, Oregon, where he used to live. In the course of that interrogation, the FBI agents informed Fikr that he would be placed on the no-fly list, but suggested that he would be removed from the list if he agreed to become an FBI informant. Fikr refused. Several months after, Fikr traveled on a business trip to UAE. There in the UAE, police arrested, imprisoned, and tortured him. In the course of his detention, UAE police interrogated him concerning his association with the same Portland mosque. During one interrogation, a UAE officer told Fikr that the FBI had requested his detention and interrogation. Fikr was eventually released from detention in the UAE, but was unable to fly home to the United States because of his status on the no-fly list, where then he decided to travel to Sweden and apply for asylum. Fikr eventually began the process of seeking to modify his no-fly list status through the DHS trip procedure. On February 2015, the Swedish government returned Fikr to Portland by a private jet, since he was on the no-fly list and could not take a commercial flight. In 2013, before leaving Sweden and before filing his inquiry, Fikr filed this lawsuit, alleging that the U.S. government had violated his substantive and procedural due process rights, which are found in the Fifth Amendment, by including him on the no-fly list and providing him inadequate means to challenge it. In 2003, George Bush executed Homeland Security Presidential Directive 6, instructing the Attorney General to create the Terrorist Screening Center. This was an intra-department entity which consolidated every government terrorist watch list into a new terrorist screening database. This database then put the people in respective lists. The most restrictive of these lists is called the no-fly list, reserved for people who pose a particular risk to domestic or international terrorism. The TSA categorically prohibits those on the no-fly list from boarding commercial airplanes which fly over the United States, and pursuant to the DHS Travel Inquiry Program, individuals on the no-fly list may inquire as to why they are placed on the list, ask for a recess of their inclusion, and request unclassified summary of the information which supports this. The defendant in the case at hand, Jonas Fikr, was a naturalized citizen, and he was informed that he was placed on the no-fly list in 2010. He began modifying his status on the no-fly list through the DHS trip procedures mentioned, and in 2013, he filed the suit that we spoke about. During the litigation proceedings, the TSA notified Fikr and the district court that he had been removed from the no-fly list while the court proceedings were still going on. The district court granted the government's motion to dismiss on grounds that the case was moot. Mootness essentially means that a case has no standing to be in front of the court because there's not an issue at hand. And the court was assessing that there was no issue at hand because he was removed from the no-fly list, which could have been essentially done to make the case moot. Fikr appealed this decision, and the United States Court of Appeals for the Ninth Circuit reversed on the grounds that the voluntary secession doctrine did not apply because the government had done nothing to assure Ficker in the court he would not simply be added to the no-fly list again after this case was dismissed. Again, on remand, the government moved to dismiss his claims, this time including a court right declaration. The district court once again dismissed his claims as moot, but on appeal, the Ninth Circuit reversed again, and that's where the Supreme Court is now granting. What this case means for the average Muslim is if Yunus is successful in his appeal, the no-fly list would be found to be unconstitutional and would be essentially dismantled from there forward. If he is denied his appeals, then the no-fly list would be deemed constitutional and would be continued in practice and also could lead to more restrictive laws being placed on Muslims. So it's very important that Yunus' case is successful. And right now, on January 8th, they did the opening arguments or the oral arguments in federal court. After the oral arguments, the judges will meet in private to discuss the case and reach a preliminary decision about the outcome of the case. If the judges disagree, the greater number becomes the majority on that case. The judges will then issue a written opinion, which will be published and made available to the public.